How much time do we have?
About 45 seconds.
Okay.
All right, 30 seconds here.
Okay, you can hear me okay?
Yep.
Okay, great.
All right, the open just started.
Okay, thanks.
Okay, go ahead.
Hello, everyone. This is Susan Betch-Tomer, and welcome to Law Talk. Today's topic is going to be about making an enforceable contract. I get a lot of people coming into my office believing that they have a breach of contract case, and sometimes they don't because they saved money on a lawyer by drawing up the contract themselves, and they don't have everything in the contract that they need. Sometimes I don't even have both people signing it. Um, so if you want to have an enforceable contract, there are certain rules that you need to follow, and one of the rules is that you should get it in writing. That's the first and foremost thing, because when you go to court, you have to prove to the judge that there was a contract. Now, I'm not saying some oral contracts aren't enforceable. There are, in theory at least, oral contracts that are enforceable. But if you have it in writing, that's much better than trying to remember or arguing about what he said or she said or what the terms of the contract were. When you have a contract in writing, it absolutely shows that A, there was a contract, so you get over that hurdle when it's in writing and both parties have signed it. And it also says what the terms of the contract are. Now, in fairness, you only need to have the person you're enforcing the contract against sign it. If the person you're trying to enforce the contract against did not sign it, you're not going to have a whole lot of luck enforcing the contract, except in certain circumstances, which we'll get to a little later. But what you want to do when you have a contract, it doesn't matter who it's with. Like some people say, well, that's my friend, it's my brother-in-law, that's, and the saddest cases are that was my mother, father, son, daughter. They didn't think they needed a contract. Well, a contract helps avoid misunderstandings in the future. People can legitimately remember things differently, or they can remember the conversations you had leading up to the making of the contract that weren't actually included in the contract that you made. So when you reduce it to writing, it is a good thing because then not only can a judge tell whether or not you have lived up to the contract or the other person has lived up to the contract, but you can remind the person, look at the contract. I see this in custody cases also when people have to say, look at the court order, look what it says. And people think it says things it doesn't say. So it's very important to have a contract. Now, a contract doesn't have to be in legalese. A contract can be in plain English, and those are actually the best kind. And the New York State Bar Association encourages us to have contracts that are easily readable and understandable by the average person. So, party of the first part is a phrase that's kind of redundant. We still use it in deeds, but it's not really used in contracts anymore because you say party of the first part and party of the second part, and then you never use those words again throughout the rest of the contract. It's best to just clearly identify people by their name. And then you can say what role it is that they're playing. So, are they the buyer? Are they the seller? Are they the mechanic? Are they the electrician? Are they the homeowner? So, say their name and who they are. Now, all contracts have to have what we in the law call certain elements, but you lay people would call, certain features or certain clauses in order to be a complete contract. So, first of all parties have to agree that there was an offer to do something or to refrain from doing something, and that there was acceptance of the offer. So, if someone says, that they're going to do something or not going to do something, the other party has to say, okay, in order for that to be the first step of a contract. The other step of a contract has to be that things of value were exchanged in order to get that thing that you're exchanging. So let's say I say, I'm going to take a certain elderly person to the doctors every Tuesday. And that person says, okay. And then some Tuesday, I fail to take them to the doctors. and they sue me. Well, that's going to get thrown out of court because there was no consideration, there was no value for that. On the other hand, if I say, I'm going to take you to the doctor's every Tuesday, and the other person says, okay, and I say, but I'm going to charge you $30, and they say, okay, then we've each gotten something of value, and that's an enforceable contract. So what the person who I'm taking to the doctors gets is the trip to the doctors, and what I get is the money involved. So that's an enforceable contract. It's probably not in writing, but the fact that I've taken you to the doctors on Tuesdays and you've given me $30, that would show, if everyone admitted that was true or able to prove that was true, that would be an enforceable contract. But they're not going to enforce it if, for example, I have a family emergency and I can't fulfill the contract. So there are all kinds of reasons why contracts can't be fulfilled, but we're not getting into that today. Today we're just going to talk about how to make an enforceable contract. So ideally, it should be in writing. There has to be an offer and an acceptance of the exact same offer. If you're not accepting the exact same offer, then there's no contract. For example, if you're going to sell a boat and you agree on a price for the boat, it's $10,000, say, and so the person who's selling the boat says, I want $10,000, and the person who's thinking about buying the boat says, well, I'll give you $10,000, but you have to throw in the tarp and the life preservers too. We don't have a contract yet. That was a counter offer. That was not an acceptance of the $10,000 price tag. That was a counter offer saying, okay, I'll give you 10,000, but only if. So what we have now is a counter offer. So the owner of the boat would have to now accept that new offer in order for there to be a contract. So there's not a contract until you have an offer and acceptance of the exact same thing. And there has to be value, which in the case of the boat is the money. Even contracts that are very clear in that way, and everyone's admitting that there's a contract, some contracts under the law have to be in writing. So that's called, the law is called the statute of frauds, and really it should be called the statute to prevent frauds, which is what it was called in Old England. It's where it comes from. But certain things have to be in writing. So contracts which by their very nature cannot be completed in a year, in order to be enforceable, has to be in writing. So an example of a contract that can't be completed in a year is if we make an agreement that for the next 3 Christmases, you're going to come to such and such a location and pretend to be Santa Claus. Okay, that can't be done within a year because the next 3 Christmases don't come within a year. So by nature, that has to be in writing if it on its face can't be completed in a year. It's not if it's typically not done in a year, or it would be unusual for it to be done in a year. The face of the contract has to say something that it would be more than a year before it could be completed. Another one is contracts involving real estate. We like to say that there's no such thing as an oral contract to buy or sell real estate in New York State. The reason for that is that real estate's a very valuable asset, and so there are all kinds of requirements as far as what the contract has to cover, but first and foremost, it has to be in writing. And so it has to describe the property clearly so that a judge can tell whether or not you're getting the property that you are paying for. So let me tell you a story about that. I know of a case where a man was buying rural property in New York State on both sides of the road. And the person who was selling it was considerably older than him, but they put it in writing. That was smart. They both signed it. That was smart. But they didn't clearly describe the property. So what happened was, not that the elderly person didn't want to do the right thing and sell the property correctly, and they didn't die either. That's something that happens sometimes. But they were in a facility because they had lacked capacity. So by the time the contract was paid off and it was time to sign the deed, the person did not have the capacity to sign the deed, did not remember even their own family, much less who my client was or what they sold them. So we had to go to court, which was long and messy. And because the property description wasn't in there, even in a basic way, we just knew that there was property on this road that was being sold on a land contract for so much money. Now the problem was the property came in different parcels. So it wasn't clear if all the parcels, it wasn't clear from the contract if all of the parcels were being sold. So we were able to get most of the land, mostly because he was living on it and working it, and the land across the street was really just woods. But the land across the street we couldn't get because it was on a different deed, and it didn't clearly say, all of the land owned by this person on such and such a road. So when you're making a contract, you have to say exactly what it is that you're selling. Are you selling this parcel of land, that parcel of land? If you're selling the boat, are you selling the accessories that go with it? If you are selling a house, are you selling the contents of the house or just the house and the land itself? You have to be especially careful if there's a mobile home on the land and you're buying it, if you think you're buying the mobile home, that it says that too. The reason for that is a mobile home is not considered a fixture on the property. So in other words, if you buy property with a mobile home on it, a mobile home is like a car. So if you bought lands and there was a car parked on it, legally, nobody would think that you were selling the car too. Well, as a matter of law, mobile homes are viewed as like cars. So no one is going to assume, and the judge is not going to enforce, that if you buy the land, you're buying the mobile home on it. So if you intend to be doing that, if you intend to buy the land and the mobile home on it, you need to say, we're buying the mobile home on it, and further identify the mobile home that's on it. Because if someone switches the mobile homes and you say, well, that's not the one that I bargained for, you're going to have a hard time proving it if it's not in the contract. So what we're talking today about is not just making contracts, but making enforceable contracts so that you can go ahead and go to court if you need to. And we're going to take a break and talk some more about this afterwards on Law Talk. How much time in the second segment, Frank?
Probably about a little under 8,
Okay, thanks.
7.5 probably. All right, just about to go. I got 30 seconds here. Okay, your rejoin just started, and it's going to be about 10 seconds short of 8 minutes, okay?
Thanks.
Okay, go ahead.
Hello and welcome back to Law Talk. We were just talking about the difference between a house on property and a mobile home on property. The mobile homes are titled like cars, unless they're really old and then they don't even have a title. But they're considered personal property. So don't assume that just because you're buying land with a mobile home on it, that the mobile home is included. The contract has to say the mobile home or whatever it is that you're doing is included. Now, there are some exceptions to the statute of frauds, and one of them is called promissory estoppel, and that's legalese. But what it means is that you promised or someone promised to do something, and the other person reasonably relied on that promise, and they would be harmed unjustly if the promise wasn't enforced. So, the most famous recent case is a June 29, 2017 decision called the State of Hennel, and it's sort of a good news, bad news situation. So what happened was there was an elderly person who owned an apartment building, and her two grandsons helped her maintain the apartment building. And she said, I'm gonna leave you this apartment building. You help me out. I'm gonna leave you this apartment building in my will." And the grandson said, "Well, Grandma, that's great, and we'd love to have it, but it's got $100,000 mortgage on it, and we don't want to pay the mortgage, so you don't need to leave it to us." And she said, "Well, no, I'll leave you money in the will to pay the mortgage, so it'll be yours free and clear. You just keep helping me out." And they said, "Well, okay, Grandma, we'll do that." And everyone agreed that that conversation had taken place, and that was what happened. Now, normally you would need a signed writing for that because it's real estate. But because everyone agreed, no one was disputing it, And because they reasonably relied on it and, for many, many years worked on grandma's apartment building, it was made an exception to the rule on promissory estoppel grounds. Unfortunately for the grandsons, even though it was an exception to the rule that it needed to be in writing, another step in that is that the results would be what the law calls unconscionable. In other words, it would be so terrible to not enforce it that the court couldn't just let it lie like that. So what happened though was that by the time grandma passed away, the mortgage was down to $80,000 and the property was worth over $230,000. And the judge said the difference between getting what you're getting and getting something that's worth 80,000 less because it has a mortgage on it is not so bad that we're going to enforce this contract. So we're not going to take the money away from the rest of the heirs in the will to give you that $80,000 to pay off the mortgage because it's just not an unfair result. You still inherited an apartment building that's worth a lot of money. So even if your contract falls within one of the exceptions where you don't need to have it in writing because of promissory estoppel or one of the other rare circumstances, you may not be able to enforce it anyway. So you really need to get everything in writing, even if it's you and grandma. And even if it's not you and grandma, people die, especially, we're in the middle of a pandemic. Young people die. People get hit by cars. Things happen all the time. So you will not be able to enforce a contract against that person's estate if you don't have good proof that the contract existed. And always the best proof that the contract existed is a written document that's signed by both parties. So in all cases, you should get a written document signed by both parties. Unless it's something you can do here and now, like I'll wash your car for $10. You don't need to get that in writing. But if you're going to wash someone's car every week for 2 years for $10, you probably need to have that in writing. So you need to think about what you're doing and how you're doing it when you're making a contract for something important or something that's going to be carried out over a long time. A, because the person may not live to fulfill their end of the bargain, and you may want to enforce it against their estate, in which case you'll need a contract. And also because people forget, they really do forget as years go by, what's in their contracts or court orders. Court orders involving custody, where there's a settlement, is really a contract that's blessed by the court. The parties agree how they're going to do things with their children, and the court says, okay, I'll make that an order. And people, forget. And so it's not infrequent that people come into my office and they tell me that someone's violating the court custody order because they're doing X, Y, and Z. And they're right about X and Y and Z, but, X and Y rather, but Z never made it to the order. So we can't say the person is violating Z if Z's not in the order. In the same way, you can't say the person is violating your contract term if the contract term isn't in the contract. It doesn't matter how many times you talked about it beforehand. The law assumes that if you intended something to be a term of the contract, having reduced your contract to writing, you would have included everything that you wanted in there. So take your time, think about it, and write it well because you're not going to get a second bite at the apple once you write that contract. Um, so that's the way it goes. Any type of business relationship, certainly you should get your contracts in writing. The New York State Bar Association requires us to have contracts in writing for all family related cases, but I get a retainer agreement, which is a type of contract in writing for every single case I do. This way, the person making a contract with and I both understand what the terms of the contract are. And there are times, and it's rare, but there are times when I've had to say to people, well, if you read your contract, you'll see, that the appeal is not included in the representation. And it never is. Appeal is a separate matter. Your case is over when the judge makes a final decision in order or whether you make an agreement that results in a final order. At that point, your case is over. If you want to continue with an appeal, that costs more money. So, and often an appeal can cost more than the initial case did because they're very complex and labor intensive, paper intensive. They take a lot of time. Usually, usually 15 to 30 hours even for a typical one that's not very complicated. So when people, a few times have said to me, well, I thought you were handling the whole case. I said, well, if you look at your contract, you'll see that it very clearly says appeals are not included, that I'm handling the case at this court, at this level, for this amount of money. But if we go beyond that, if you want to appeal, if things go against you, you need to hire an appellate attorney. Now, I'm happy to be your appellate attorney. It's part of the things that I do. But you may wish to hire another appellate attorney, but it's not included in your initial retainer fee. So business relationships very important. Um, you need to not take somebody's word for it that you're going to be included in their will, because the courts very much want to leave wills alone. If people bother to make them, they want to do it just the way it says. So if you're taking care of an elderly person with the promise that you're going to be put in their will, you need to get a contract. You need to get that in writing that you're going to leave me this thing in the will. And sometimes it can be a good idea, if the person is going to leave you something, to have them sign it over to you with them having a life use of it. So this way you already technically own it. And we're having to go for another break. So we'll see you in a minute at 3.
All right, so you're going to have about 7.5, somewhere between 7.5 and 8 minutes.
Okay, thank you.
Yep.
So the lighting is really bad here. I think we're going to have to do a home studio. It looks like. Frank, are we going to be back in the studio anytime soon, or is this going to be the new normal for a while?
I think it's probably going to be the new normal for a while because we haven't even recorded spots.
Okay.
We've been doing everything even spots-wise over the phone.
Okay, then I guess I will bother to set up something resembling a home studio here.
All right, 30 seconds here.
Thank you.
All right, your rejoin has started. Go ahead.
All right, so we've been talking about how to make an enforceable contract, and I'm going to talk to you about some of the things that people do wrong when they're making contracts. One of the things that people do wrong when they're making contracts is they'll write, for example, for a land contract, they'll write rent in the memo line when they're actually buying the place on a land contract. So assigned writing can be checks. If you write down mortgage or rent to buy in the memo line and the other person cashes it, that means that they're agreeing that the money is to rent to own, not just rent. And I've seen cases repeatedly where people think they're renting to own, so they just write rent in the memo line, and then they try to show how much they've paid towards the house. And that's not towards the house if it says rent. So make sure whatever you write in the memo line, make sure it captures in as few words as possible what it is that you're actually doing and paying for. Sometimes you have to write down every detail in order for it to be clear. For example, let's take the land contract again. You're buying land and you agree to pay, $500 a month for 15 years, and then the property is yours. And you even remember to write, and then the landowner will sign a deed over to you, giving you the property. But you didn't write in who's going to pay for the deed to be drawn up. You didn't write in who's going to pay for the filing fees. And you didn't write in how long after your last payment the person has to sign the deed over to you. So those are important details if you're trying to get your property in your name. So you will want to have those details in, saying, the person has 30 days or 60 days or 10 days after you present them with a deed if you're paying for the deed. So you really want to make sure that that detail is in there. The ultimate how does what you want happen should have a lot of details in it so that it happens. Again, if someone passes away, then the person who owns the house, who's selling the house, passes away. Well, then you can't enforce it against their estate because the executor of the estate, if you don't have it in writing, I'm saying you can't enforce it against the estate at all, because the person who has the estate, the executor, is obligated to do what the will says and nothing else. And so they can't give you something out of fairness because they know this or that. You need to prove that there's a contract, especially if anyone's disputing it. But even if they're not disputing it, the executor is obligated to do whatever the will says. And if the will doesn't say what you think it should say, or it doesn't mention your contract and you don't have it in writing, you're not going to get your land probably. So you want to make sure that it's in writing so that it's enforceable. Now, let's say the person who is buying the thing on the land contract dies and there isn't anything in writing. And let's assume you get over the statute of frauds hurdle because everyone's agreeing that it was there, and it wouldn't be fair to have that money be kept by the person who was receiving it and not give some value for the real estate. You still have a difficulty proving, as the widow or widower or family member of the person who's buying, that they have an ownership interest in that house, or mobile home and land, that they have something coming to them, that they have something to sell. It may be that you're only halfway through the contract, but you have what's called equity in that. You have an ownership interest. You own a certain percentage of it by the time you've paid so much for it. But if you're the buyer and something happens to you, your estate can't enforce that contract if there is no contract that anyone can find. Another thing that's important to do is put your contract in a safe place. Now, for wills, you can file wills, that may be subject to a contract with the surrogate's court, and then it's in a safe place because the surrogate's court already has it. Other courts don't allow that kind of convenience for you, so you should put the contract that is signed by both of you in a safe place. And if the other person, the seller, often wants to keep the contract, then you need to get a copy of that contract that is signed by both of you. Don't accept a copy that's a copy of the contract before it was signed by both of you, or that's not signed at all, or it's just signed by one person. You want a copy of the contract that's signed by both of you in case you need to enforce it, because you'll need to show the judge that there was agreement because both of you signed it. So that's really important, is to make sure that you get a contract, even if it's in writing, if you want it to be enforceable, that it's in a safe place and signed by both people. An offer doesn't stay open forever. So if somebody makes you an offer and says, hey, I'll sell you this land for $30,000, and then you come back and you want to buy it for $30,000 next year, you waited too long to accept it. I'm told right now, because people are moving out of New York City in droves. I was just speaking to a friend of mine on Long Island. So she says that on Long Island, the real estate market is so hot that people are offering $20,000 or $30,000 over the asking price. They're so desperate to get out of New York City and buy a home in a suburb because of the civil unrest and lack of safety that's occurring in New York City, or at least the perceived civil unrest and lack of safety that's occurring in New York City right now. So you'll want to make sure that you have it in writing. So if somebody offers you $20,000 more and you're in that happy circumstance, you want to get that in the contract. Obviously, you are only asking X amount of dollars. If they offer you X plus 20,000, you want to get that in the contract, you're getting paid more than you asked. So that's important too. So the offers don't stay open forever. Counter offers can be made to any offer. And again, if a counter offer is made, that's a brand new offer. It starts the cycle over again. So going back to the example I used before, the boat, I'll sell you the boat for $10,000, and then the other person comes back with, well, I'll pay you $10,000 if you throw in the tarp and the life preservers. I would then have to say yes, because the $10,000 with the boat, the tarp, and the life preservers is not an acceptance of my offer. It's a brand new offer. So I have to accept that or not. But if I want to get the $10,000 and go through with the deal, I have to accept it. So some of the other things that are a mistake is copy and pasting things from the internet without really reading them or understanding what they mean. Not reading a contract before you sign it because you think you know what's in it. You need to make sure everything you believe is in it should be. You need to negotiate terms you don't like. Just because a printed contract is given to you doesn't mean you can't negotiate what's in it. You can cross it out, both of you initial it, change the wording, and then that's the new contract. So you don't have to accept a contract that says things you don't like. Now, of course, every time you want to cross something out and initial it, that's a new offer to the person who's selling you something or whatever it is that you're contracting to do. So both people have to initial any changes in the contract. It's no good to just cross it out or have one person initial it, because again, you need to enforce these terms against the person you're enforcing them against. You have to prove that they agreed to these terms. And we're out of time, so we'll see you next week on Law Talk. Have a great week, everybody. Bye-bye.
Join us every Tuesday for Law Talk right here on the Patriot, 1230 and 1450 AM, 106.9 and 103.3 FM.
All right.
All right.
Thanks.
Have a good day.
Thank you. You too. Thanks a lot.